A court of appeal in Abuja has halted the reinstatement of Alhaji Muhammadu Sanusi II as the Emir of Kano. A three-member panel of justices led by Justice Okun Abang on Friday unanimously halted the implementation of the January 10 judgment, which vacated the nullification of Sanusi's II's appointment by a Kano State High Court, which it held was done without jurisdiction. The judgment, which was delivered by Justice Gabriel Kolawole, held that the nullification of Sanusi's II's appointment was done without the required jurisdiction and ordered the transfer of the suit to the Kano State High Court. However, ruling on the fresh applications, the appellate court agreed that the application seeking to halt the enforcement of the earlier judgment pending the appeal before the Supreme Court were competent and meritorious. He also noted that the subject matter before the courts needs to be preserved because the applicant had served as Emir for 5 years before his removal, adding that he deserves the right to protection. Over to you, Mr. Ogochukwu. I mean, before now we've had issues of this same installment of the Emir of Kano State, yes, when it started, and it appears that it has been resolved when Sanusi was, installed as the Emir of Kano State. Now our appeal court have stopped his reinstatement again the second time. Let me get your take on this.
The appeal court judgment, this particular judgment appeal court gave now is reminding me of what led to the installment of the case of Nnamdi Kanu.
Okay.
How can a court, the same court, to be speaking from both sides of the mouth? This case has gotten to the appeal court. The appeal court affirmed the reinstatement of Sanusi. Then now, which case now went to Supreme Court? Somebody now applied to the Supreme Court. Is the case in the Supreme Court, did the Supreme Court direct them, as they did in the case of Nnamdi Kanu, to now go and start the retrial from the trial court? The answer is no. The Supreme Court have not said anything about this particular case. So why will the appeal court now coming to have double standard on its own judgment it has already given? Hence, the trial court, the lower court, this case emanated from, didn't have the jurisdiction to hear this particular case. Remember, why that case went to the Federal High Court, just like what happens in River State. You run to the court where you'll be protected. The Adebayero went to the Federal High Court in Kano to obtain his own judgment because of his synergy between him and Nuhu Ribado, the NSA, and the affiliation he has with the federal government. Because he knows that hence the governor is the sole appointee of those judges in the State High Court. He might not get his needed judgment. He now overlooked, because this is a matter that should even be heard within the customary court. I was even, as I was going through those expose yesterday, I was asking myself, why will a traditional institutional case be going to the Supreme Court? For what?
We actually had this discussion initially.
Yes, initially when
yes,
this,
we talked
yes,
about it.
I now said they don't have. It shouldn't even leave the state.
Good.
Even the State House Assembly, we are in the Constitution. We are given the powers to legislate how the state will run its own government, local government, and these traditional institutions. It shouldn't be seen as something that will go to the federal. What does the federal? The staff of office is being given by the state governor. The state governor is the person that holds the land in trust for the people in the Land Use Act. The state governor is the person who is domiciled in the locality to see what those traditional rulers are doing. They are well within his purview, his whims and caprices. It is also the state governor who creates new autonomous communities. who elevates chiefs to either first class, second class, or third class, the case may be. So, Victor, I was trying to wrap my mind why the Supreme Court will entertain such case. I don't understand this. So, for the appeal court to now be double standing and grandstanding in this particular issue is what I don't know. They should have maintained the appeal of what the judgment of the appeal court. Let Sanusi be installed. Just like what happened in Rivers State here. The governor went to appeal court went against him. He still disobeyed before but if the governor has started obeying some of those court judgments with the time being, see, there is a way to kill, there are different ways to kill mosquito. You can allow those people, like the governor said before in Rivers State, to be floating. But what you do is that channel of communication, you just quietly, allow it to fizzle away. You don't send correspondence to them. You don't. Now them go, they call you for correspondence safe.
All right.
But you look at how Obasanjo issue and article happened. After Obasanjo was able to get his second tenure, after kneeling down before Atiku, and Atiku, what happened? When he came in, he quietly, rendered Atiku's office, non-functional. Just like we saw the one that happened between Obaseki and Shaibu. Even when Shaibu was reinstated, what happened? All the correspondence that should go to the office of the the deputy governor was denied him. But Obasanjo paid Atiku his money, removed him from the National Economic Council, and made sure he stifled him of those funds that normally overflow to his office. The governor of Rivers State would have done that, and this particular appeal would have allowed Sanusi to be pending the determination of the case in the Supreme Court. Okay, what will the Supreme Court say now? The Supreme Court will say, okay, go back to the trial court, which is the state high court, because once a case have jurisdictional issue, just like the Rivers State, they're talking about the defection, property defection, and all that. But when the case got to the appeal court, what happened? The appeal court said the state high court had no jurisdiction to hear this matter. That means it is as good as you did not have a case at hand. So if they get to the Supreme Court now, and the Supreme Court says that Federal High Court, ab initio, has no jurisdiction to hear this matter, where does that leave us?
All right.
Does that leave us to now start from the trial court again? So appeal court should have stood their ground and have not played this grandstanding double standard role they are playing now, in order to let them be seen as not sounding prejudice. But they have given a judgment. From what we have seen, they have already given a pronouncement. Why not have that pronouncement done now? If you are going if you are making a pronouncement of maintain the status quo antebellum, which we also saw in Rivers State here, we also saw that pronouncement given on behalf of Martin Samehule. But the governor did not obey it. So antebellum means before the case even went to the trial court. That is what. But does appeal court have the powers to make that pronouncement? I don't know.
All right.
Because do you know that? You know why I am saying that? If a judgment had been given from a trial court, it still remains a judgment.
All right.
I don't know if you get it. It still remains a judgment. So for you now to say that let them maintain antebellum status quo means that they should return when Adebayero was the Emir. But the case has gone through the first trial court. So me, I am yet to wrap my head around it and really understand why the appeal court is making such a statement. But the Kano State government has come to clarify. I read in other their own press release that the statement of the appeal court is being misunderstood, that Sanusi is still the Emir until the Supreme Court makes final pronouncement.